Welcome to ALP Corner, Family Law in the Heart of Houston.
Welcome to ALP Corner, Family Law in the Heart of Houston. I'm your host, Abigail Vaca, and today I'm joined by Allecia L. Pottinger. Thank you for joining me again today.
It's always a pleasure, Abigail. Always a pleasure.
So let's jump right in. What are some common reasons that parents or spouses might seek a modification to a custody or child support order?
Typically, let's start with the easier one, child support. There's two things that a person would want to modify a court order to either increase the child support or decrease the child support. So those factors, the court has a statutory language that says if the order would reduce or increase the original amount by $100 or at least 20% of the original order, that is an automatic pass. You get that child support either increased or decreased. If it doesn't reach that level, then you are SOL, shit out of luck, and you just don't, get a modification in that situation when you're dealing with the child support. Now, the bigger thing, the modification, when we talk about with children, as we kind of discussed in our last episode, the situations and circumstances that would require modification may be a geographical restriction, and the parent may want to move outside of the geographical restriction. There's been a change in circumstance in which I've even had where the kids are being abused in the home, and you need emergency orders in order to get the children out of the house and into the other parent's possession. And so it can be a penumbrum of issues. It just depends. But the ultimate determining factor is what's in the best interest of the children.
So what factors does the court consider when deciding whether to approve a modification of a family court order in Texas?
Abigail, it goes back to that best interest standard. I hate to sound like a broken record, but it really is in what's in the best interest of the children. And you will find that there are situations where children are being abused or neglected, and you need emergency orders to get the children away from the individual who's abusing. We've even had cases where mom or dad may be living with a sex offender or someone who's been convicted of family violence. And of course, we don't want kiddos living with individuals who have been convicted of family violence and also are registered sex offenders. It's just not really kosher. So yes, but for the most part, geo restrictions, they don't like them. They don't really consider them in the best interest of the children. So you have to be very careful and know your court when you basically are dealing with modifications.
How would you know if your situation qualifies for a modification? And what steps should someone take if they believe that a change is necessary?
They should talk to an experienced family law attorney, because there are certain buzzwords or buzz situations that really will ignite the court and make the court want to really change and modify custody arrangements. And what you will find is sometimes people think that just as the fact that mom has to work extra hours and the child may be with a babysitter for a few hours, or the fact that dad has a new girlfriend that I haven't met, and so I don't think that the child should go over to dad's house because I haven't met the new girlfriend. Those are not reasons to change custody. And then they're not going to get you very far. And if you talk to an experienced attorney before you make those particular decisions, they can give you some guidance on what the court will and probably will not do.
How difficult is it to modify a family court order? Are there certain challenges that arise when trying to change custody or visitation arrangements?
Absolutely. There are some little tricky things that happen First of all, you have to understand that courts don't like change. They feel like children, they need a routine, they need structure. And so if I'm going to change it, it needs to be for a good reason. And so you really need to buttress your reason, not just like, I'll give you a scenario. Mom has a babysitter, after hours because I have to work. Now take that situation and you magnify it. Mom is out more, or the child is with the babysitter more than with mom, or the child is with the grandma more than with mom. In those particular situations, I think the court can make a determination that, if between grandma and dad would be the better parent, not grandma, to foster or to raise that particular child. And so you have factors that the court is looking at in order to determine what's in the best interest of the kids. So, but it always goes back to that standard. And you have courts that are very quirky about certain things. And so you need that experienced attorney to be able to dive in and understand what the dynamics are.
And what role do both parents' cooperation and communication play in the modification process? Is it possible to modify an order without going to court?
No, okay, that depends on how you look at going to court. Yes, you can modify the order without having to go to trial if the parties agree on a modification, but it needs to go through court and it needs to have the judge to sign off on that modification for it to be valid and enforceable later in the future. But the modification process can be done fairly quickly if the parties can agree. If the parties don't agree, then you're looking at a fight, and that's going to have to go to the court for a determination and as to whether that modification will take place. Did I answer your question, Abigail?
You did, and it leads me to a follow-up question. If one parent is not adhering to the existing family court order, how can a family law attorney assist in enforcing or seeking a modification to that order?
Okay, so just in my years of practice, the first thing that you want to do is you want to enforce the order. And the reason why you want to enforce the order is that you want to show the court that this other party is not following its orders. You need about 2 or 3 times where you're showing the court that the other party is just not going to follow the order before you can get a modification based on that rationale to flip custody. So it's best to start with an enforcement. And with an enforcement, it's very, very, very technical. An enforcement is a quasi-criminal proceeding. So the other party, the respondent, has to be read their rights, have to understand that they are entitled to a jury trial for the enforcement. Yeah. They're also entitled, if they're indigent, they're entitled to an attorney to represent them free of charge. But the issue is what is in the best interest of the child and whether they violated the order and the order is specific enough that they knew what they were supposed to do at the time in which they did it. Very technical, the way that, because it's a quasi-criminal proceeding, you have to be very careful on how you draft, how you present your case, and understand that the other side has a right not to testify in that proceeding because of the criminal nature of it. Outside of that, once the court sees that this person is not following the court order, they say, you can't follow the court order. I'm just going to switch custody here because it makes no sense that we have to come down here. I have to admonish you. I have to make you pay attorney fees or threaten to throw you in jail. The court gets they just don't like it when they hear that their court orders are not followed. And I get it,
That makes sense. So I'd like to wrap up today by having you tell us, why is it crucial to have a family law attorney when seeking a modification to an existing family court order, such as custody or child support?
You always need to understand what the law is and what the dynamics are in order to do a modification. If you don't know what those little quirks that the judges have with respect to modifications, then you end up in court and not getting the relief that you want. So it's best to start with an experienced attorney to help you navigate that process versus trying to do it yourself and end up with zero results and probably hurt your chances in the future for modifying a court order. Because once you try and modify, there's a thing called res judicata that attaches to certain cases, and that says that the thing has been decided. So you can't go back and revisit that same situation because the court has already decided on that. So it's just best that you start off with an experienced attorney. If nothing else, get a consultation to understand what your rights are and what your privileges and duties and rights are with respect to that court order.
Thank you so much for answering all of my questions today. It was a pleasure chatting with you.
Always, Abigail, a pleasure talking with you. And then I just run my mouth, but bottom line, you asked pointed questions, and so I appreciate that. And I love to tell people about what they can expect in the family law area.
They're going to learn a lot from what you shared today.
Thank you.
And thank you for joining us for ALP Corner, Family Law in the Heart of Houston. Be sure to like, subscribe, and leave a review on our channel.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.